Hi, everyone, and welcome. My name is Kristen Chung, and I am a co-chair of the Western Law Distinguished Speakers Committee. And on behalf of my co-chairs, Greer Hope and Dylan Gohill, and the entire committee, thank you so much for joining us at our first event of the 2021-22 academic year. We are honored and so very grateful to have Justice Jamal of the Supreme Court of Canada here with us today to speak on the incredibly important topic of diversity in the legal profession and the judiciary. And before I pass things to Dean Chamberlain to officially open today's event and to introduce Justice Jamal, I'll just mention a couple of technical aspects. So first off, a quick note to let you know that the event is being recorded. And secondly, we'll have a question and answer portion after Justice Jamal's talk, which Greer and Dylan will moderate. And a number of you did submit questions in advance, which was wonderful. And we do also encourage you to use the Q&A function at the bottom of your screen if you have any other questions to send in throughout the talk. So with that, I'm delighted to pass things to Dean Chamberlain.
Thanks very much, Kristen. Good afternoon, everyone, and welcome to this exciting event in our Distinguished Speakers Series at Western Law. For those of you joining from outside the faculty, my name is Erica Chamberlain. I'm a dean and professor here, and I'm honored to assist with the launch of this year's series. The Distinguished Speaker Series is longstanding here at Western Law. It's a joint initiative of our Student Legal Society and the faculty, and this is a great way to kick things off. As we begin, I'd like to acknowledge that Western University is situated on the traditional lands of the Anishinaabe, Haudenosaunee, Lenape-Wakan Attawandaron peoples, on lands connected with the London Township and Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. It is my great pleasure today to introduce the newest Justice of the Supreme Court of Canada, the Honourable Mr. Justice Mahmud Jamal. Justice Jamal was elevated from the Court of Appeals for Ontario, where he had served since 2019, following a truly outstanding career as a litigator. Working in the areas of constitutional and public law, class actions, and commercial law, Jamal appeared before the courts of 7 provinces, the federal court, the tax court, and no fewer than 35 times before the Supreme Court of Canada. He obtained his bachelor's degree from the University of Toronto, his Bachelor of Laws and Bachelor of Civil Laws degrees from McGill, and his LLM from Yale. He was a judicial law clerk at both the Quebec Court of Appeal and the Supreme Court of Canada, where he served Mr. Justice Gontier. He's been active with the Canadian Civil Liberties Association, the Advocate Society, and the Osgood Society for Canadian Legal History, and has taught at both McGill and Osgood Hall Law Schools. While practicing at Osler, he was the chair of his firm's National Pro Bono program and has been a vocal proponent of lawyers' obligations to use their skills for the public good. Justice Jamal is well respected for his intellect, his eloquence, and his collegiality, both toward lawyers and toward his judicial colleagues. It was no surprise then that his historic appointment earlier this year was universally celebrated. In that vein, I had the occasion to speak a few months ago with former Supreme Court Justice Ian Binney, before whom Justice Jamal appeared as appellate counsel on several occasions. And Binney remarked that if there were ever anyone who was born to be a Supreme Court Justice, it was Mahmud Jamal. So please join me in welcoming him virtually to Western Law today.
Well, thank you very much, Dean Chamberlain, for that incredibly kind introduction. I'd also like to thank Ms. Kristen Chung, Ms. Greer Hope, and Mr. Dylan Gohill, and the Western Distinguished Speakers Committee for inviting me to speak to you today. I wish it could be in person, but I'm delighted to be here virtually. I'm especially happy to be joining you at Western Law, and I say this for several reasons. I'm happy because your dean had an important role in selecting me to serve on the Supreme Court of Canada. I'm happy because one of your professors, Dr. Randy Graham, is my former colleague as a Supreme Court law clerk and is someone whom I've watched with admiration as his academic and literary careers have flourished. I'm also happy because 2 of this school's former professors, Justices Grant Huscroft and Justice Brad Miller, are 2 friends and former colleagues at the Court of Appeal for Ontario, for whom I have the highest regard and from whom I always learned a great deal when I sat with them. But I'm especially happy because I have the chance to speak to you, the students of Western law. I know that among you are future leaders of the Canadian legal community, future judges, managing partners of law firms, advocates before the Supreme Court of Canada and other courts, and people who will make a difference in the law in innumerable ways. I know that may seem hard for you to believe today, especially as you begin to prepare for your December exams, but it's undoubtedly true, as I think you will see in the years ahead. My topic today is diversity in Canada's judiciary. Now, you may be thinking, why another talk on the importance of diversity? My answer is simple. Although there may be an emerging public consensus on the importance of diversity in Canada's judiciary, I share the view of those who say that we must keep talking about this issue. We must keep making the case until the judiciary and the legal profession generally reflect the diversity of the Canadians that they serve. I also agree with those who say that talk alone is not enough, that we must take concrete action institutionally and individually to make diversity a reality in our profession. So in my remarks, I hope to address why we should care about judicial diversity, why we should all care, and I'll explore three main rationale for diversity in the Canadian judiciary. I'll do so by drawing on the published reflections of the first three female Supreme Court of Canada justices, Justice Bertha Wilson, Justice Claire Leroux-Dubé, and Chief Justice Beverley McLachlin. I'll also review some of the progress that's been made in enhancing diversity in the federal judiciary. So with that, let me begin with the rationale for enhancing diversity in Canada's judiciary. This isn't a new issue. Judges in the Supreme Court of Canada have been supporting greater diversity in the judiciary for over 30 years and have sometimes stoked controversy by doing so. Justice Bertha Wilson famously made the case for greater gender diversity, calling for more women on the bench in her Betjeman lecture at Osgoode Hall Law School in February 1990, which was her last year on the Supreme Court of Canada. In the title of her speech, Justice Wilson asked what was then considered a provocative question. She asked, will women judges really make a difference? Many of us have read that speech at some point, but it's worth rereading today. The speech largely consisted of a review of the scholarly literature on the perspectives that women bring to the role of judging, the role of identity in judicial decision-making, and how women's perspective and identity fit with the then traditional idea of judicial independence and impartiality. For the most part, Justice Wilson was careful not to venture any opinion. She simply raised questions instead of answers, although there's very little doubt about her views or her intended message. Rereading that speech today, like others, I am struck by how moderate her observations were. She articulated what many would consider essential truths and unquestioned orthodoxy. Some scholars have noted, in fact, that the most provocative part of her speech might well have been the title. Yet the speech at the time set off a storm of controversy, and the press erupted into a furor, according to Justice Wilson's biographer, Ellen Anderson. Within a week, a complaint had been lodged with the Canadian Judicial Council, seeking Justice Wilson's removal from the bench for allegedly expressing feminist views and violating her judicial oath of impartiality. Her biographer, Ellen Anderson, notes that Justice Wilson's speech took courage because of the potential redefinition of the traditional value of judicial objectivity and neutrality, which the feminist stance entailed, even though Justice Wilson herself had insisted that she did not know if women judges would make a difference. She was merely willing to raise the question. Later justices of the Supreme Court of Canada have continued to call for greater judicial diversity, including, among others, former Justice Claire Leroux-Dubé, former Chief Justice Beverley McLachlin, and Chief Justice Richard Wagner. And judges at all levels of court across Canada have echoed their calls for action. So in essence, there have been three main arguments for greater diversity in Canada's judiciary. The first is that judicial diversity enhances the judiciary's institutional legitimacy. The second is that judicial diversity improves the quality of judicial decision-making. And the third is that judicial diversity is important because public institutions must be open and must be seen to be open to all Canadians, but especially to young Canadians. I'll say a few words about each argument. So let me start with the first argument. Many eminent judges have endorsed the view that judicial diversity improves the judiciary's institutional legitimacy by enhancing public trust and confidence in the justice system. One of the first to do so was Justice Wilson herself. In her famous paper, she cited the American judge Gladys Kessler to the effect that, quote, the ultimate justification for deliberately seeking judges of both sexes and all colors and backgrounds is to keep the public's trust. The public must perceive its judges to be fair, impartial, and representative of the diversity of those who are being judged. Justice Wilson also cited Justice Patricia Wald's view that women judges are indispensable to the public's confidence in the ability of the courts to respond to the legal problems of all classes of citizens. Fast forward 20 years, and Chief Justice McLaughlin's view that there is value in people seeing a bench that includes at least some people like them. Chief Justice McLaughlin noted that representativeness in this sense is about ensuring that the public sees itself reflected in the judiciary. It's about legitimacy and public confidence. Chief Justice McLaughlin acknowledged in her words that, quote, many people, particularly women and visible minorities, may have less than complete trust in a system composed exclusively or predominantly of middle-aged white men in pinstripe trousers. They will question whether such a court can reflect the various viewpoints and values of an increasingly pluralistic society. She also accepted that while it may be impossible to have a bench that perfectly mirrors society in all its diversity, nevertheless, she said, if great segments of the population are excluded or represented only by the occasional token judge, public confidence in the administration of justice may suffer. In her view, therefore, diversity on the bench can only enhance the credibility of our justice system and the repute of the administration of justice. Chief Justice McLaughlin elaborated on this view in her memoir, Truth Be Told, and there she said that the courts belong to the people and should reflect the people. No one should be obliged to go before a court that seems distant or alien, a truth that she said applies not only to women as judges, but also to minorities, including Indigenous peoples who have felt that the courts are not theirs, that they don't represent them or understand them. And Chief Justice McLaughlin urged, therefore, that what we need now is a diverse representation on the bench. She said it may take time, but we should do all we can to get there. This view has been echoed by Chief Justice Richard Wagner. In 2020, he said that all Canadians should be able to see themselves reflected in their justice system, that justice should not make a person feel like an outsider or an other when they confront it. And he repeated this message earlier this year, emphasizing that when judges reflect the makeup of society, this builds public confidence in the justice system. So I've spoken a lot about public confidence in the justice system. Why is it so important to have public confidence in the justice system? Let me cite two responses, both of which hold that public confidence is the ultimate repository for the authority and legitimacy of both the judiciary and the law. So a first response is provided by Chief Justice McLaughlin. She cited the US Supreme Court Justice Stephen Breyer, who argued that the public ultimately accepts and follows the decisions of the judiciary, a body which he described as, quote, inoffensive, technical, and comparatively powerless, because he said that there is public confidence in the judiciary as an institution. A second response is provided by Chief Justice George Strathey, and in fact was provided just a few weeks ago in marking the opening of the courts of Ontario for 2021. And there, in addressing the role of public confidence in maintaining the rule of law, Chief Justice Strathey cited the 2019 Reith Lecture Series of former UK Supreme Court Judge Lord Jonathan Sumption. And Lord Sumption argued that people obey the law only partly, but not even mainly, because of the fear of punishment, but rather because they acknowledge the legitimacy of the law. He defined legitimacy as, quote, a collective instinct that we owe it to each other to accept the authority of our institutions, even when we don't like what they're doing. He said it depends on an unspoken sense that we are in it together. So to summarize, judicial diversity enhances the judiciary's institutional legitimacy by ensuring that those judges who judge Canadians reflect and represent those who are judged. By doing so, judicial diversity builds public confidence in the justice system, and it helps cement the sense that we are all in this together, that constitutional democracy is a collective enterprise in which there is room for everyone at the table. And Canadians then willingly accept the decisions of those who judge them, even if they don't always agree with those decisions, because they respect the institution of a diverse and representative judiciary. So that's the first rationale. A second rationale for judicial diversity is that it leads to better and more informed judicial decisions. In a word, to better justice. Now, some may view this claim as difficult, if not impossible, to establish empirically, given the principle of deliberative secrecy. But it's worth noting that each of the first 3 women judges on the Supreme Court of Canada embraced it wholeheartedly. For them, gender diversity on the bench undeniably enhances the quality of justice by bringing different perspectives to bear on the task of judging. So in her Betjeman lecture, Justice Wilson mused that women judges and lawyers might make a difference by drawing on their differing perspectives on life to bring, quote, a new humanity to bear on the decision-making process. She said that in this way, women judges might succeed in infusing the law with an understanding of what it means to be fully human. She'd done so herself, of course, in many cases, including famously in the Queen and Lavallee, just a few months after her lecture, by accepting that evidence of battered woman syndrome is relevant to self-defense in criminal law. She therefore drew on what Professor Colleen Shepherd has called abused women's experiential knowledge. Justice Wilson also did so 2 years earlier in the Queen and Morgentaler, involving the unconstitutionality of Canada's former criminal law restricting access to abortion. And there she said that it was, quote, probably impossible for a man to respond, even imaginatively, to the dilemma a woman faces in deciding whether to terminate a pregnancy, because it's outside the realm of his personal experience, and because a man can relate to the decision only by objectifying it, thereby eliminating the subjective elements of the female psyche, which are at the heart of the dilemma. So for Justice Wilson, the lived experience of a woman judge is a unique and essential reservoir of perspectives to draw on when judging. Now, just after 7 years after Justice Wilson's speech, the second woman to sit on the Supreme Court of Canada, Justice Claire Lheureux-Dubé, she made similar observations. She said that women's diverse experiences have been sadly lacking in many areas of the law, and highlighted the need to incorporate them in our judicial decisions. She had also done so in many areas of the law, ranging from taxation to criminal law. And she also explicitly broadened the range of relevant diversity, stating that in making a difference, judges cannot only be concerned about women's reality, but also about the varying and diverse experiences of children, men, people with disabilities, people of color, people who are poor, members of Canada's First Nations, and all other types of human experience, which may form the background against which the law is applied. The third woman to sit on the Supreme Court of Canada, Chief Justice McLaughlin, concurred. In 2012, she remarked that diversity on the bench is a useful way to bring different and important points of view and perspectives to judging. Diverse perspectives, she said, enrich the judging process and may lead to better decisions. She described, based on her own experience, how she'd seen deliberations take a new turn because of the perspective brought by a woman to an issue involving a woman. And she'd also said she's seen the court culture change as the number of women on the Supreme Court had increased. Chief Justice McLaughlin developed some of these ideas in her memoir, and she repeated that perspectives matter. In describing some of the lessons she'd learned from the case of Tremblay versus Daigle, involving whether a father could obtain an injunction to prevent a mother from having an abortion, she noted that, quote, judges of different backgrounds and genders ensure a deep and full discussion that gives due weight to the concerns of each party. And she warned that one of the dangers that judges face is that they may overlook or treat too lightly a particular fact or situation. So she concluded, quote, that a balanced bench guards against the problem of missing perspectives. I think if we reflect on what these judges have said, I think there is something in the nature of the judicial function that helps explain why judicial diversity enhances the quality of judicial decision-making. If you think about it, a judge's role involves an exercise of judicial empathy. To quote Justice Wilson again, a judge must enter the skin of the litigant and make his or her experience part of your experience, and only when you've done that to judge. Chief Justice McLaughlin gave this idea of judicial empathy a name. She called it conscious objectivity, and she described it as an act of the imagination that involves the judge putting themselves in the shoes of the different parties and thinking about how the issue looks from their perspective. Now, not surprisingly, there are different views about whether a lived experience of diversity is essential to undertake this act of imagination required by conscious objectivity. Justice Wilson's comments in Morgenthaler to the effect that it's probably impossible for a man to respond even imaginatively to the dilemma a woman faces in making decisions about her reproductive life because it's outside the realm of his personal experience, suggests that a lived experience may be essential in at least some cases. By contrast, Justice Leroux-Dubé highlighted that neither men nor women form a monolith or homogeneous group, and that different women judges have approached the concerns of women in different ways. She also, in fairness, highlighted that some male judges, such as Chief Justice Brian Dixon and Justice Jean Betts, were extremely gender sensitive and deeply understood the issues that women face. For her, the import of this is that everyone who's in a position of power is bound to make a difference. She said we all have a shared responsibility to understand the perspectives which differ from our own and to reflect these in the law, particularly where these have been met in the past with dismissive or stereotype-driven responses or simply with silence. Justice Leroux-Dubé therefore emphasized that what we must seek to do is to develop an increased sensitivity on the part of all judges to the diverse human experiences which are presented to the courts on a daily basis. At a time when our courts are increasingly confronted with concerns of systemic racism, racial profiling, stereotyping, unconscious bias, and other forms of discrimination, it's all the more important that judges reflect the diversity of the affected Canadians who are raising these important legal issues before the courts. As judges, we are also responsible for becoming and remaining more culturally competent. I think any judge who's been a member of an appellate or collegial court, where judges decide in panels or groups, will tell you that they make better decisions when they're informed by the diverse perspectives and life experiences of their colleagues, whether they be women, Indigenous or racialized persons, or members of other diverse groups. So this takes me to the third rationale for judicial diversity, which is that judicial diversity allows Canadians, and especially young Canadians, and I would say people like those of you watching who are at law school, to see that public institutions are open to them and that they too can aspire to hold important positions of public office. Although this also promotes the institutional legitimacy of the courts, I think it's a sufficiently important and distinct consideration to warrant separate mention. This point was emphasized by a former Ontario Chief Justice Roy McMurtry in a speech he gave in 2007. And he explained then that a diverse bench allows society, and especially young people, to see minorities excelling in every area of important human endeavor. Or in the powerful words of children's rights activist Marian Wright Edelman, you can't be what you can't see. There's perhaps no better example of this than the appointment of Chief Justice Beverley McLachlin as the first Chief Justice of Canada. In her memoir, Chief Justice McLachlin chronicled her life from modest beginnings in rural Pincher Creek, Alberta, to law school in Edmonton, to law teaching in Vancouver, and ultimately to the office of Chief Justice of Canada. As the third woman on the Supreme Court, she deeply understood the significance of her nomination to women and girls. On the day of her swearing in as a Supreme Court judge, she reflected on how her nomination was a moment of pride, tempered only by the thought of how many women in decades past have been denied the immense privilege of sitting on our country's highest court. And then about halfway through her first decade of Chief Justice, she described how she had a eureka moment. She realized that being chief wasn't just about the Supreme Court of Canada, however important that was, that the people of Canada viewed the Chief Justice as their Chief Justice. And she recounted a story that she'd often hear, that she would often hear at the court's open house, at public events, or even at the grocery store checkout line. A father would take his daughter's hand and say, "See, that's the Chief Justice of Canada. You can do that too." And she said she would look into the daughter's eyes and realize that just by being there, a woman in the third highest position in the land was of huge importance. She said, quote, "I came to see that perhaps the most important takeaway from my time as Chief Justice would be that I, a woman, had been there and had spoken out for the values I cherished." Chief Justice McLachlin candidly acknowledged the challenges of being a symbol and a source of inspiration to many. She said that being the first can sometimes be daunting, that everyone is waiting and watching, some rooting for you, and some secretly hoping you'll fail. And she said that the future of those who follow rests on how you fare. So to sum up, in Canada today, a diverse judiciary is essential. Diversity improves the judiciary's institutional legitimacy, it enhances the quality of judicial decision-making, and it conveys to all Canadians, and especially to young Canadians, the public institutions are open to them and that they too can and should aspire to judicial office, including to the highest judicial office in the land. These claims have implications, I think, for the relationship between judicial diversity and merit. Merit is not evaluated first, separate and apart from judicial diversity, with diversity coming into play in judicial selection only as a tiebreaker once there is a short list of people of merit. Rather, diversity in all its forms is itself a component of merit. Chief Justice McLachlin, and I quote, "We should only appoint people of merit. We must never compromise on the quality of the judges we appoint." But she was quick to add, and I quote, "Merit must be understood in the sense of ability to do the job and in full appreciation of the diverse perspectives and legitimacy that judges from diverse backgrounds bring to the bench." She said that when we understand merit in this way, we open the door to appointing women and minorities and to building a judiciary that is a more accurate reflection of the society it serves. So where are we today regarding judicial diversity in Canada? I think it's fair to say that significant progress has been made in the last 30 years. In 1990, when Justice Wilson gave her famous speech, just over 9% of federally appointed judges were women. In 1997, 7 years later, Justice Laura Dubé noted that the number had risen to 12%, with the proportion of women represented in new judicial appointments growing at a higher rate than ever before. Neither Justice Wilson nor Justice Laura Dubé cited data on the proportion of Indigenous or racialized judges, though the numbers were no doubt small. By 2012, another 15 years later, Chief Justice McLaughlin noted that the number of women judges had now risen to about 32%, with 4 women on the Supreme Court of Canada: Chief Justice McLaughlin herself, Justice Marie Deschamps, Justice Rosalie Abella, and Justice Andromache Karakatsanis. And she remarked, Chief Justice McLaughlin that is, that while Canadian judges belong to various religious and linguistic groups, we are very largely Caucasian. Today, according to data published by the Office of the Commissioner for Federal Judicial Affairs Canada, that's current as of November 1st, 2021, about 44% of the federally appointed judges across Canada are women. Of the 1,198 federally appointed judges, 526 are women, with 37 current vacancies. So at 44%, Canada is finally on the cusp of gender parity on the federal bench. We aren't there yet, but it's not far from parity. And according to the Commissioner's data, in 2016 and 2017, a majority of both new appointments and elevations to courts of appeal were women, and women now form a majority of the appellate judges on the courts of appeal of Alberta, Manitoba, and Newfoundland and Labrador. More judges are also being appointed who are Indigenous, racialized, LGBTQ2, or who identify as having a disability. Because I've not seen aggregate data in these particular categories, it's hard to evaluate how Canada is faring nationally, although I think it's fair to say that the proportions of Indigenous and racialized judges still lag the proportions in the general population. So although we're a distance from having a judiciary that appropriately reflects the diversity of Canadians, I think it's very fair to note, as Chief Justice Wagner did in his end-of-year news conference in June of this year, that across Canada, our courts are more diverse than ever. So as I close, I want to again quote Justice Wilson's famous speech. She stressed that bringing about change is the shared obligation of everyone in the legal profession. She emphasized that it would be a Pyrrhic victory for women and the justice system as a whole if changes in the law come only through the efforts of women lawyers and women judges. Justice Laura Dubé echoed this concern. She said that it's the responsibility of the entire legal profession to develop the awareness needed to listen to and understand those voices which are different from our own, whether of judges or those who come before us seeking justice. In her words, we cannot place solely on women judges and others belonging to groups which are underrepresented in the judiciary the burden of understanding and responding to the concerns of those who have met with insensitivity in the law. Reflecting and understanding the rich diversity of Canadians is thus the shared responsibility of us all. The project will succeed only if we each do our part. It's been a great privilege to speak to you today. I would again like to thank the Western Distinguished Speaker Series Committee for inviting me. Thank you all for listening.
Thank you very much, Justice Jamal. We've received a number of questions for you, and myself, my co-chair, Greer, will read out those questions. For our audience members, we continue to invite you to submit questions, and you can do so through the Q&A icon at the bottom of your screen. Our first question comes from Megan, and she asks, are there any experiences that you had as a clerk for Justice Gontier that are helping to guide you now as a Supreme Court Justice?
Well, absolutely. I think every aspect of your legal career is a source of instruction and guidance. I mean, having been a Supreme Court clerk, I think I try to imagine what it is like to be a clerk. I try to tell my clerks about the flow of the year, about the nature of the work, about how it's important to take breaks, to recharge, because it's a very, very demanding job as a law clerk. And I know from having done it that it's pretty much 24/7 for a year. And so I've tried to underscore the importance to them of pacing themselves, of taking time for themselves, of taking breaks. And I say the same thing to law students. Frankly, it's a very can be a very demanding profession, so it's very important to take time for self-care, to look after yourself. So that certainly helped me in my interaction with my clerks, to try and get the best out of them and to make sure that they have a good year and that we work together. I think also seeing the flow of the year and how the cases gradually get decided is obviously something I am able to draw on. You start in September, preparing for cases in October, and in principle, at least, you have a bit of a clear deck from the summer. In my case, I had a clear deck because I wasn't sitting, obviously, previously. But you see the workload gradually build in terms of hearings and reserves. So I think the experience of being a clerk certainly helps, even though it was a long time ago, certainly helps being a judge and trying to understand the perspectives of the law clerks that are working with you.
Amazing. Thank you so much, Justice Jamal. Our next question comes from Grace, and she asks, looking ahead to the future, have you thought about what kind of legacy you would like to leave as a Supreme Court judge, or about the kind of judge that you would like to be remembered as?
Well, thank you very much, Grace, for that question. I don't think of it, honestly, I don't think about it in those terms. I really do think about deciding case by case. I don't think in the broad sweep of 25 years or 20 years or however long I could be on the court. I think about it as preparing for the next case and doing the best I can. And I say that because often I don't know what I'm going to decide on a particular case until I start really getting deeply into the briefs, and getting into the briefs, speaking about the issues with my colleagues, and then obviously hearing the oral argument, and then further deepening the discussion with the post-hearing deliberations. So I don't think about, I've spoken in my parliamentary testimony about not having an agenda or having a goal about what it is I want to accomplish. I just want to do case by case the best job I can, and I try to genuinely come to a case with an open mind. I think having been a litigator, I always wanted the judges to come to court with an open mind, to be willing to listen to what it is I had to say. And so I try and remember that. It wasn't so long ago as a lawyer. So I try and remember that. I try and say, even though if I've got a leaning going into a hearing, that I'm going to keep as open a mind as possible to listen to the counsel. And if I've got questions, to put them respectfully to counsel so that I can get a better understanding of the issues. So I don't think about it in terms of a long-term legacy. I want to take it case by case, and also I want lawyers to think that they get a good hearing. I want the lawyers to think that I'm prepared, to hope that they think I'm prepared, that any lawyer who comes to the Supreme Court is entitled to, we call a hot bench, meaning a prepared bench, one that's ready to ask intelligent questions. So that's what I try and do, and you try and do that case by case, and then legacies will take care of themselves after that.
Thank you. Our next question comes from Nikki. She says, one of the criticisms of the legal system is that precedent itself is built on bias against minorities. How do you feel as a member of one of our highest court, reconcile the importance of precedent with the hidden bias within it?
Well, that's a difficult and multi-layered question, but it's something that actually Justice Wilson herself addressed in her Betjeman lecture and her Osgood speech. And if there are any of you who haven't read that speech, I urge you to read it, because even 31 years later, it's got an extraordinary amount to draw upon. And she spoke about her own she started the speech by talking about her own sense of limitations, that even though she was lauded and congratulated when she came to the bench, and how she received messages of support, that it was wonderful that there was finally a woman on the Supreme Court, that would be, the beginning of change in the law. She noted that she didn't have the same sense of extraordinary optimism, because the law is a conservative institution, that the law doesn't change overnight, and that it takes a long time for the law to change. And that's why she spoke about it being a Pyrrhic victory. If it's only women who bring about change, that it has to be everybody who brings about change in perspectives. And I really do believe that I believe that there's a lot of truth to that it's everybody's responsibility to bring about change in the law, not just the judges who are on the courts, but law students and lawyers who are arguing before the courts. Lawyers to bring perspectives to bear to judges' deliberations, and that means educating the judges on perspectives that may be missing. That's why we have a relatively liberal policy towards interveners in the Supreme Court of Canada, so that we can hear these different perspectives. And that means it's the obligation of lawyers to educate the judges on the different perspectives on how a particular decision will fit into the fabric of the law, whether the law is built on, as you say, biases, gender biases, or racial or other biases, and that maybe the law leads to change. But for that to happen, it requires everybody, including law students and lawyers, to actually educate judges. So change can come about, change does come about, but it's a shared enterprise that everybody has to have a stake in.
Thank you so much. Our next question comes from Lauren, and they ask, those from marginalized communities who pursue a career in law are successful due to our mentors and sponsors. Who were your mentors and sponsors in your career, and how do you envision doing the same?
Well, I had so many mentors throughout my career. I had mentors at law school. Some of the professors I worked with, a fellow by the name, the late Patrick Glenn, was an extraordinary mentor, a very famous professor of comparative law. The judges I clerked for, Justices Rothman and Gontier, Rothman at the Quebec Court of Appeal and Justice Gontier at the Supreme Court. I mean, they were exemplars about how to conduct yourself as a judge, and I don't think you could have better role models than those two individuals. I had mentors as a young lawyer, and there really is so many to name, but I'll mention a few. J. Edgar Sexton, when I was a young lawyer, who later went to the Federal Court of Appeal, and I think was a graduate of your faculty, was a mentor. He was the chair of OSLAS for many, many years and the head of its litigation department. Peter Corey was a mentor. After he retired from the Supreme Court of Canada, he joined the firm I was at. Edward Saunders, another retired judge who joined the firm. A lawyer named by the name of Deborah Glendenning was a mentor. She was the head of the litigation department. And happily, the firm I was at had a strong history of strong women in leadership roles, including Bertha Wilson, Deborah Glendenning, managing partner, who's a woman. So she was another role model and mentor. And then later on, when I became a judge, I would say there were role models and mentors there. Chief Justice Strathy, Justice Russell Jurians, Justice Jim McPherson. So, I think we need role models and mentors at each stage of our careers. I don't think it stops when you hit 25. You have to have people you can look up to, and they can be younger people you can look up to. They don't have to necessarily be older people. So I think it's extraordinarily important to have people who can guide you, give you advice, be role models. And I've been very, very lucky that I've had many of them. Two other ones, Justice Marshall Rothstein, after he retired from the Supreme Court, somebody I got to work with. I'd appeared before him over 20 years, 25 years as he was a judge, but I got to know him closely when he came back to practice. And somebody that Dean Chamberlain mentioned, Ian Binney, was a mentor for many, many years. I got to know him as a law clerk, and then worked with him before he was appointed to the Supreme Court, and then after he returned to practice. So I've been very, very lucky. There have been so many people over so many years who've kind of taken me under their wing and been my sponsor or a mentor or encourager, however you want to put it. So I think we all need that. And I think what students should do, if I can venture this, you should seek people out. You shouldn't wait for them. You shouldn't wait to be mentored. You should seek people out. And that means some, if there's somebody you want to get advice from, write to them a polite email, a short email, or write them a letter, write them a handwritten letter. I mean, it's remarkable. Getting a handwritten letter from somebody is something you take notice of, and you might get a response. So, seek out people to get advice from. In terms of what I've tried to do and what I try to do still is, I interact with lots and lots of young lawyers and lawyers who are in law students, clerks, obviously, my clerks at the Court of Appeal, but also at the Supreme Court. I try and stay in touch with them. Even though it hasn't been that long, I do try and stay in touch with them. They still get in touch with me for career advice, firms to choose, how to navigate their careers. And I tell people to, try and have a 5-year plan, to stick it out, wherever it is you start, for the first few years, because it's very difficult in the first few years in legal practice. At least it was for me. And so you've got to kind of have a bit of resilience and stick it out, at least for the first few years, because every year in legal practice is better than the last. So the hardest years are the first. And for that, you need to have people who can encourage you, but you also need to have a degree of personal resilience.
Thank you. Our next question comes from Arian, and he asks, on the date of your appointment to the Supreme Court, you were pictured holding 2 books in your hands. What is the significance of those books, and how do they inform your approach as a judge?
Oh, well, I think the books were a book of Baha'i prayers and the Kitabi Akdas, which is the book of laws in the Baha'i faith. So I think I spoke during my testimony about becoming a Baha'i, and so it's part of the religious books of the faith I am a member of. The significance is that they are important sources of inspiration and guidance and sacred texts in my faith. So just as somebody might swear their oath on the Bible, I swore mine on the religious books in my faith. So that was very significant for me. And when you swear in as a judge, when you get sworn in as a judge, you get a special Bible or other religious text, so which is then kind of a commemorative copy. So I was very happy that to have those to hopefully give to my children one day. So that's what those were.
Awesome. Thank you so much. We have another question here. This one's from Christine. And she says, a barrier to entry that has been identified in adding diversity to the Supreme Court, particularly with respect to Indigenous justices, is the bilingual requirement. Are there discussions within the court on how to approach this requirement for Indigenous members of the judiciary?
Well, I certainly couldn't speak about any internal discussions inside the Supreme Court of Canada out of obvious respect to my colleagues. But I can say that from my own experience, being bilingual is important in the work of the court. It's essential, in fact. Many of the materials are only submitted in one language, and despite there being excellent simultaneous translators for oral hearings, a lot of the memoranda, internal memoranda, a lot of the documents are in French. So certainly from a functional perspective, I don't know how one would function effectively would be very difficult. So I think that's the reason for the requirement, given the nature of the work of the court. But I can't speak to, as I say, to internal discussions.
Thank you. Our next question comes from Samantha and Travis. They ask, what is one thing that you wish you had known prior to entering the legal profession?
Well, I think it's what I've really already said, which is about the importance of resilience. You don't have one career as a lawyer, you have multiple careers. You have a career as a law student, you have a career as a young lawyer, you have a career as a mid-level associate or lawyer. And so I think it's sorry, pardon me, I just got somebody, one of these notifications came on my screen. What was the question again? Sorry.
This is one thing that you wish you had known prior to entering
yes.
the profession.
Yes. Well, I was about the idea of resilience was what I was talking about. You have multiple careers, and it's very, very important just to realize that you're going to have multiple careers. So don't think too far ahead, and stick with it. Really stick with it. Don't get discouraged. You have to have a degree of endurance in the legal profession, both as a law student, but also as a lawyer.
Thank you. And I think we have time for one more question. So this question comes from Edith, and she says, how can the Supreme Court make its processes more accessible and understandable to those whose communities may have felt and may still feel excluded from the legal profession and from legal decision making?
Well, I think the Supreme Court and all courts are doing their best to make their processes more accessible. One of the byproducts of the pandemic is that, for example, all courts, but including the Supreme Court of Canada, have got much more used to video technology, which avoids the need to fly to Ottawa to stay in a hotel, and with all the costs associated with that. So I think there has been a significant access to justice dimension from having video hearings. I think it's also allowed for a lot more use of digital filing and digital preparation of records. There is a lot less paper around a courtroom today than there used to be. And obviously, the more that can be done to streamline the rules and the internal processes of the court to make them more accessible. And I would say also to make the court's decisions more accessible. The more that can be done to make the court's decisions intelligible, readable, succinct, I think enhances access to justice. So I think all those things can improve access to justice.
Thank you so much. So I think that is our time for today. So on behalf of the Distinguished Speakers Committee and the audience that's joined us, I want to sincerely thank you, Justice Jamal, for taking the time out to present your talk. You provided us with an extremely relevant and insightful discussion that I'm sure resonated with many and inspired many of those in attendance. As a small token of our appreciation and gratitude, we will be sending a small gift, which you should receive in the mail. I'd also like to take a moment to thank Dean Chamberlain for providing today's introduction. And finally, I would like to thank all of you in the audience for attending and engaging with today's talk. We hope to see you all at our next event. Thank you again, everyone, and have a wonderful day.
Thank you.